Breaking! The U.S. legal system. Judge Cannon has dismissed the Florida documents case because she claims Jack Smith was illegally appointed as a special counsel. This is a completely bonkers, made-up decision that flies in the face of the Constitution, federal statutes, Supreme Court authority directly on point, and federal appeals court decisions that are also directly on point. It is a partisan decision that has no chance of being upheld by the 11th Circuit, but we live in a world where I have no idea what the Supreme Court would do if it takes this up. So who knows if in a year or two the Supreme Court might bless this and overrule 5 decades of precedent. But based on current law, this decision is nuts. But to understand that, you have to understand what is a special counsel. At base, this case is simply about whether there's statutory authority for attorney generals to appoint people to investigate and prosecute. And the answer is yes, there is authority, and attorneys general have been exercising it since the 19th century. Now, special or independent counsels have been around in one form or another for almost 150 years. President Ulysses S. Grant appointed the first independent counsel to investigate corruption in his administration, though he did fire that guy when he indicted Grant's personal secretary for defrauding the government. But Congress expanded that authority in 1966 when it passed 28 U.S.C. 533, which says that the Attorney General may, quote, appoint officials to detect and prosecute crimes against the United States. Now, after the fallout from Watergate, Congress passed the Ethics and Government Act in 1978, which authorized the appointment of independent counsels. And that act was used to investigate President Bill Clinton's Whitewater real estate deals, which eventually turned into an investigation over his affair with Monica Lewinsky. In 1999, the statute expired and Congress did not reauthorize it, in large part because many Congress members on both sides thought that Ken Starr's investigation was too independent and too far-ranging. And that illustrates the fundamental conflict with all these appointments is that the special counsel needs to be independent enough from the executive to investigate and prosecute the executive, but not so independent that they run wild. But there was still a need for an independent investigative process, so in 1999, the Justice Department promulgated the rules governing the appointment of special counsels, relying on the Attorney General's general administrative hiring authority. And special counsels have served similar roles as independent counsels or special prosecutors. The Attorney General generally has the authority to appoint, supervise, and remove them, and that means that neither Congress nor the President can unilaterally fire a special counsel. And in the last 3 decades, there have been many special counsels on both sides of the aisle, including the Russia investigation led by Republican Robert Mueller, the investigation of Joe Biden for retaining government documents led by Republican Robert Hur, the investigation of whether Mueller was too mean to Trump led by Republican John Durham, and the investigation of Hunter Biden, which was led by Republican David Weiss. But it is odd that while the targets of the investigations have been on both sides of the aisle, the special counsel has almost always been Republican. But on November 18, 2022, Attorney General Merrick Garland issued an order appointing John Smith as special counsel after Donald Trump announced his candidacy for president. Smith's mandate was to investigate whether Trump unlawfully interfered with the 2020 presidential election and certification of the Electoral College vote, and whether Trump broke any laws when he removed classified documents and other presidential records from the White House to Mar-a-Lago. Now, much of Cannon's decision rests on who can appoint officers and inferior officers under the Constitution. So before we get further into this, here's the lay of the land when it comes to this particular legal question. Article 2, Section 2, Clause 2 of the Constitution is the Appointments Clause. It grants the President the, quote, power to appoint with the advice and consent of the Senate, ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. It goes on to say that, quote, Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments. So generally, some high officers, usually referred to as principal officers, in the executive branch must be appointed and confirmed by the Senate. This includes heads of departments like the Attorney General or the Secretary of State. Now, inferior officers can be appointed by the heads of departments, such as the Attorney General for the DOJ, so long as Congress has authorized the head of the department to make the appointment of that inferior officer. So in this case, if the special counsel is an inferior officer, then there just needs to be a statute authorizing the Attorney General to appoint them. If the special counsel were considered a principal officer, like a cabinet member, then they would need to be confirmed by the Senate. Now, for the most part, Judge Cannon assumed for the purposes of argument that the special counsel was some kind of inferior officer. So this whole question was whether Congress authorized the Attorney General to appoint the special counsel. Now, admittedly, there is also a controversy over whether the special counsel is even an inferior officer. They might just be a DOJ employee, which would circumvent all of this. But let's just ignore that for the moment. Now, there are many statutes which almost all lawyers and judges believe gives the Attorney General the right to appoint special counsels, especially 28 U.S.C. Section 515B, which states, quote, each attorney specially retained under authority of the Department of Justice shall be commissioned as a special assistant to the Attorney General or special attorney and shall take the oath required by law. Foreign counsel employed in special cases are not required to take the oath. The Attorney General shall fix the annual salary of a special assistant or special attorney. Yeah, so that sounds like it authorizes the AG to appoint special counsels to conduct legal proceedings. And then there's 28 U.S.C. 533. Quote, the Attorney General may appoint officials, 1, to detect and prosecute crimes against the United States, and 4, to conduct such other investigations regarding official matters under the control of the Department of Justice and the Department of State as may be directed by the Attorney General. Again, this is pretty direct authority for the Attorney General to appoint special counsels. And so far, every court that has looked at this has found that a special counsel was permitted. That includes at least 1 Supreme Court case, 5 federal courts of appeal, and 9 federal district court cases. And many of those have been penned by Republicans. Now, obviously, if you have a legal issue and don't have Judge Cannon in your pocket, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've suffered a data breach, especially if you got one of those data breach letters saying that your social security number was leaked, were involved in a car crash, or are dealing with an immigration issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery and find out what your options are. So just click on the link in the description or call the number that's on screen right now for a free consultation with my team. Because you don't just need the legal team, you need the Eagle Team. So the link is below. But Judge Cannon disregards all of that and found that the relevant statutes did not authorize Jack Smith's appointment. To do so, Cannon had to get around the Supreme Court's decision in the United States versus Nixon. Now, the unanimous court in U.S. versus Nixon held that, quote, under the authority of Article 2, Section 2, Congress has vested in the Attorney General the power to conduct the criminal litigation of the United States government, 28 U.S.C. 516. It also has vested in him the power to appoint subordinate officers and assist him in the discharge of his duties, 28 U.S.C. 509, 510, 515, 533. Acting pursuant to those statutes, the Attorney General has delegated the authority to represent the United States in these particular matters to a special prosecutor with unique authority and tenure. The regulation gives the special prosecutor explicit power to contest the invocation of executive privilege in the process of seeking evidence deemed relevant to the performance of these specially designated duties. Now, that's about as on point as a Supreme Court case gets. The Supreme Court says that Congress has vested in the AG the power to appoint subordinate officers to act as special prosecutors. So why does Cannon disregard such precedent? Well, she dismissed that holding as dictum, something she doesn't have to follow because it was peripheral to the issues presented. Now, dicta or dictum singular is a part of a case that isn't binding because it isn't necessary for the outcome of the case, which just is not true here. If the court had felt that the issue went the other way, it would have invalidated the special prosecutor's subpoena and appointment in the U.S. versus Nixon. This was the case where Leon Jaworski, the special prosecutor, subpoenaed the Nixon tapes from the White House that ultimately led to Nixon's resignation from the White House. And even if this section of the case were dicta, it's pretty unusual for a district court not to follow the Supreme Court's dicta where it reflects a clear statement of law. And instead, she followed a concurrence by Justice Thomas in the recent immunity case Trump versus the United States. And ironically, she's following a concurrence which no other justice joined. And in that case, the Smith appointment wasn't even an issue in that case. But it appears that Thomas wanted to tee up that issue specifically for Cannon. Now, Thomas critiqued Nixon because he didn't like its analysis and he thought it was too short. Quote, if the court gave passing reference to the cited statutes as supporting the appointment of the special prosecutor in the United States versus Nixon, but it provided no analysis of those provisions' texts. So obviously Cannon treated Thomas's commentary, which no other justice joined, as if it was gospel rather than giving the Nixon case any weight. And similarly, Judge Cannon also disregards 2 appellate opinions in the D.C. Circuit, which are also directly on point. Cannon dismissed those as wrongly decided because they relied so extensively on the Nixon case, which she believes is wrongly decided. Quote, the Nixon dictum has taken on significance in related cases, and a full explication of the record is necessary. Now, those 2 D.C. Circuit cases are pretty illustrative. In the 1987 case, In Re Sealed Case, that dealt with the appointment of an independent counsel for the Iran-Contra scandal and found the appointment valid. The court held, quote, we have no difficulty concluding that the Attorney General possessed the statutory authority to create the Office of Independent Counsel Iran-Contra and to convey it to the investigative and prosecutorial functions and powers described in 28 CFR Section 600.1a of the regulation. While these provisions do not explicitly authorize the Attorney General to create an Office of Independent Counsel virtually free of ongoing supervision, we read them as accommodating the delegation at issue here. Now, that issue about supervision goes to a question about whether the old independent counsel was too independent, and we'll talk about that in a second. But the important thing here is that the D.C. Circuit specifically found that some of the exact same regulations gave the Attorney General authority to appoint an independent counsel. And then there is the 2019 case of In Re grand jury investigation that dealt with the appointment of Robert Mueller, written by a Republican judge. There, the court held, quote, Special Counsel Mueller effectively serves at the pleasure of the executive branch officer who was appointed with the advice and consent of the Senate. The control thereby maintained means the special counsel is an inferior officer. Miller's contention that special counsel Mueller is a principal officer under the Appointments Clause thus fails. Oh, and that case also addressed the dicta question. Quote, in this analysis, the Attorney General's statutory authority to issue the regulations was a necessary antecedent to determining whether the regulations were valid and therefore was necessary to the decision that a justiciable controversy existed. The Supreme Court's quoted statement regarding the Attorney General's power to appoint subordinate officers is, therefore, not dictum. But Cannon rejects those questions, as well as the Supreme Court's Nixon case, on the basis that those cases did not analyze the wording of the underlying statutes, which is crazy. You'll note that all of those quotations cite to the statutes. Some are the exact same statutes at issue in this case. And when courts cite the statute, it means that it analyzed the statute and found that it supports the proposition that it's stating. So basically, she didn't follow those cases because they relied on Nixon, which she considers dictum, even though one of the cases explicitly says that Nixon was not dictum. And she did not believe that they analyzed the issue deeply enough, even though they analyzed the same statutes. Cannon then decides that a Scalia dissent in another Supreme Court case, Morrison versus Olson, was persuasive, which is odd because in that case, the Supreme Court actually held that Congress may grant authority to the judicial branch to appoint independent counsel without violating the separation of powers. In Morrison versus Olson, Chief Justice and Republican William Rehnquist, writing for a 7-1 court, held that an independent counsel was an inferior officer, largely because the counsel was subject to removal by a higher executive branch official. They had limited duties and had limited jurisdiction and tenure. And the court rejected Olson's argument that the act encroached upon the executive power since it allowed the Attorney General to remove independent counsel for good cause. Now, in that case, Scalia was the lone dissenter. He thought that the act violated the separation of powers by giving judicial officers the power to appoint and supervise executive officers, the special counsel. He believed that this infringed on the president's exclusive power to execute the laws. Now, this was in reference to the old independent counsel statute, where the counsel was appointed by a 3-judge panel rather than the attorney general. The idea was that the 3-judge panel would be insulated from politics. But that created potentially separation of powers issues because it was then the judicial branch creating executive branch officers. But even that was considered constitutionally sound according to the Supreme Court. And Scalia's dissent doesn't even apply to the appointment of Jack Smith because Smith was appointed and supervised by the Attorney General, not by the judicial branch. Now, in addition to disregarding binding authority from the Supreme Court for reasons, Cannon plays a bunch of linguistic tricks. Cannon analyzes Section 515, but says that the reference to a lawyer being retained does not mean it allows the Attorney General to appoint them. Now, her argument is that the word retained means that the special counsel must have already been appointed to the Department of Justice in the past and can't come from the outside. It's a distinction that appears to try to safeguard the special counsel in the Hunter Biden case, but still invalidate Jack Smith, since the Hunter Biden special counsel was already a standing United States attorney. But it would be silly for the statute to only allow for retaining someone already appointed, and the statute clearly contemplates retaining them for the first time pursuant to that statute. Not to mention the statute requires them to take an oath, which they already would have done if they had been previously appointed as an inferior or principal officer of the United States. Not to mention, this is the process of how special counsels, independent counsels, and special prosecutors have been selected for decades. In fact, Leon Jaworski, the special prosecutor in U.S. versus Nixon, was chosen from outside of the Department of Justice, just like Jack Smith was. But Cannon writes that, quote, Mr. Smith is a private citizen exercising the full power of a United States attorney and with very little oversight or supervision. But that's completely wrong. First of all, the special counsel doesn't have nearly the same scope of authority as a U.S. attorney. And second of all, the special counsel is bound by all of the same rules of the Department of Justice and is supervised by the Attorney General. Further, according to Cannon, Smith and special counsels are not an official, which is the word used in Section 533. Section 533 allows the Attorney General to appoint officials. Cannon goes to great convulsions to show that officer and official are incredibly different words with very different meanings. And to come to that conclusion, she doesn't use any kind of legal authority. She uses a handful of cherry-picked, out-of-date dictionary definitions. Now, I'll spare you that analysis because it's nonsense, but for over 50 years, the Supreme Court and like 13 other courts have made it clear that official includes officers. Further, she writes that, quote, Section 533's use of the phrase detect and prosecute crimes does not otherwise transform the provision into a grant of special counsel appointing authority. Here she concludes that this section of the statute is only about FBI employees and doesn't relate at all to other law enforcement personnel, such as lawyers who work at the Department of Justice, which is just anti-textualist. That's not what the law says. It's also extremely weird because the FBI does not and cannot prosecute anyone. That's the job of the assistant U.S. attorneys. So this section literally cannot only refer to the FBI. Finally, in one of the last sections of Cannon's decision, she suggests that Jack Smith is too independent to be considered even an inferior officer, and it might be the case that the special counsel is a principal officer, like the Attorney General himself, which would require Senate approval no matter what. But ultimately, she just throws her hands up and says it's complicated and that a higher court should make that call. Quote, after examining the broad language in the Supreme Court cases on the subject and seeing a mixed picture, even if a compelling one in favor of principal designation, the court elects with reservations to reject the principal officer's submission and to leave the matter for review by higher courts. Hey, it's important to know your own limitations as a jurist. And additionally, Judge Cannon also found that Smith's funding was unlawful for the same reasons the appointment was unconstitutional, that she claims there wasn't a statute that covered it. But that argument is simply duplicative of all the other statutory misinterpretations she does earlier in the decision. Peter Carr, the spokesman for Smith, issued a statement, quote, the dismissal of the case deviates from the uniform conclusion of all previous courts to have considered the issue that the Attorney General is statutorily authorized to appoint special counsel. The Justice Department has authorized the special counsel to appeal the court's order. Now, it's likely that Smith has been looking for a way to appeal Cannon's orders and perhaps to get her removed from the case for quite some time, but until now, Cannon has avoided deciding a legal issue that would be reviewable by the 11th Circuit. But her removal from the case is far from a sure thing. The 11th Circuit will only remove Cannon if there is clear evidence of bias, and that legal standard is very tough to meet. The two disqualification statutes are 28 U.S.C. 455 and 28 U.S.C. 144, and to disqualify Cannon for personal bias, Smith would have to show the bias or prejudice was personal and from an extrajudicial source, and the fact that Trump appointed Cannon is irrelevant to this determination. The 11th Circuit has rebuked Cannon before, but by grounding part of her decision in Justice Thomas's interpretation of the special counsel, it has a fig leaf of legitimacy. But in any event, Smith's appeal won't be decided anytime soon. If the 11th Circuit reverses, then the Supreme Court will get a crack at it, which puts this well into 2025. And in theory, Smith or Attorney General Garland could refile the case using a U.S. attorney, though that would be ironic because they would be under the more direct supervision of the Attorney General, which appointing a special counsel was meant to avoid, so they would be politically insulated. But if things are refiled instead of going through the appellate process, there are questions of whether that might reset the investigation and prosecution back to 2022. Now, if you enjoyed this analysis, I go into more detail in the version that's available on today's sponsor, Nebula. On Nebula, you can always watch my videos ad-free and early because my videos always go up on Nebula first. And for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest deal of all. Plus, there's tons of exclusive content. For example, we just released an exclusive reaction to the military law movie Rules of Engagement, and that one will never be on YouTube because it's about some really unsavory crimes and Marines. And for every upload that I do, I always try to provide just a little bit more insight into the topics and analysis for the version that goes up on Nebula. And I know tens of thousands of you signed up for Nebula using the CuriosityStream bundle, but unfortunately that's over. CuriosityStream has informed us, and even included in their latest SEC filing, that they don't intend to pay us bundle revenue in 2024. That means that I and my fellow Nebula creators won't get any money from bundle subscribers. So the bundle is breaking and you're not going to be able to have access to Nebula anymore after 2024. So if you want to support me and this channel, the only way to ensure that that money that you spend on Nebula actually goes to us is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. With your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and of course, LegalEagle. And the exclusives on Nebula are getting really good. We have a whole slate of exciting projects this year. Right now, I'm really enjoying Jetlag The Getaway. It involves some of my absolute favorite people doing some crazy travel-related challenges, but it's all rigged in a way that basically they're playing Secret Hitler, but everyone is Hitler. It's really, really hilarious. And of course, you can always watch my other Nebula exclusive content like my feature-length documentary Bad Law Words Good, my full-length interview with the screenwriter of My Cousin Vinny, and my Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters. And because it's a subscription service, we get to work on larger, higher-budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And for those of you that want to share everything Nebula has to offer with your friends and family, Nebula also offers annual gift cards. So if you sign up using the link that's on screen right now or down in the description, you can give a year of Nebula to a friend for 40% off the yearly subscription. And that friend can be you if you want. So you can get a 40% off discount for you or a friend's yearly subscription, or you can check out Lifetime, where for $300 you can get access to Nebula forever, and with your purchase going to fund creation of even more exciting originals than ever before. In a way, lifetime is the best possible deal of all. Either way, you'll get all my videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on for our own streaming site. So sign up now and get you or a friend 40% off of Nebula, or get the incredible lifetime deal by clicking on the link below. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.